Good morning to all of you. Today we are going to discuss the topic private nuisance. Yesterday I told you in detail regarding the public nuisance. Basically, nuisance is nothing but unlawful, unjust, unreasonable interference in the enjoyment of right of a particular individual, which causes annoyance, which causes exasperation, which causes irritation to the minds of the others. This is what is called nuisance. And you know there are two types of nuisances. One is public nuisance and the other one is private nuisance. So private nuisance means the nuisance caused to a particular individual. An individual or a small family or a little group of persons. Here, in this private nuisance, the defendant may interfere with the plaintiff unnecessarily and also unreasonably. So, for example, you are in the house, morning you went to the office and came back to the house in the evening, and when you want to relax, if your neighbor raises the volume of TV, it causes irritation, is it not? This is what is called private nuisance. You are disturbed or your family is disturbed. This is a private nuisance. Suppose if the mic is fitted to the outside and so many people are disgusted, it is public nuisance, right? Your neighbor has planted some trees. So the trees have grown up, the branches of the trees protruded to the compound wall and damaged the compound wall. It is a private nuisance. The leaves of the so-called tree, they have almost encroached over the top of the roof and they have spoiled the roof. Yes, it is also private nuisance. In this case, you can go, as I already told you, you can go for a tort, you can go for a civil case, you can go for a criminal case, and you can approach the Mandal Executive Magistrate who can take action under section 133 CRPC for the removal of nuisances. Particularly, they relate to land and property and other things. Right. Now, let's discuss a couple of case laws that will be better for you to appreciate. First case law, very famous case law. Radhesham versus Guru Prasad, 1978. Right? Mr. Radhesham, he has started a ginning mill. Ginning mill, you may be knowing. So the cotton will be there. The cotton will be brought, it will be ginned, it will be kept at certain humidity or certain temperature. After that, after ginning and processing, it will be exported to other countries or it will be exported to Tirupur, Madurai and other places where it will be formed into a cloth. So this is what is called a ginning mill, and in Prakasham districts, number of ginning mills are there. Right. So after some time, the defendant, that is Guru Prasad, he obtained permission to start a brick factory or brick kiln by the side of the so-called ginning mill, right? So the plaintiff objected by saying that there is danger by fire to the ginning mill. Suppose if the brick kiln burns, the sparks may come and definitely the cotton may be set fire. There is a danger of fire, right? Moreover, the dust, definitely when the manufacturing of bricks, definitely dust will be there. The dust of the bricks would spoil the quality of cotton, because if they accumulate on the white cotton, white iron, definitely the color will change. So there will be a nuisance. So with these two headings, he has filed a case. Right. Allahabad High Court agreed with the argument and said yes, it is a private nuisance to the so-called ginning mill. Therefore, it has granted injunction. This man should not work there. And of course, he has to shift the premises to some other place. This is what happened. Another case, Helen's Smelting Company versus Tipping, 1865. You may be knowing, zinc smelting factory. So this zinc smelting factory, while smelting, definitely carbon monoxide, carbon dioxide, so many noxious gases will come and they will spoil definitely the vicinity. So it is already noted. Actually, the entire area is notified. So the area where the smelting company is there, normally the entire area is notified. Okay. So the people are not residing there. But what about the trees? The trees, due to this smelting process and the fumes coming outside, they get first black, they withered away. So lot of environmental pollution has come. Right. Now, some people, the Tipping, who is a resident of the nearby area, he filed a case of tort against Helen Smelting Company, right? Okay, because the trees belong to him. Main point, the trees belong to him. So the smelting company stated that they pleaded about the denotification and also voluntary non-fit injuria, and it is for the purpose or for the benefit of the common man. All these things they have discussed, but ultimately the court held that this damage to the trees is treated as a nuisance, so they have to pay compensation, right? Another case is there, Alapati Venkatrao versus Nizamapatnam Sachinana, like in 1980. This happened in Tenali. There is a rice mill belonging to this Nizamapatnam Sachinana. Of course, there are two types of rice mills, huller mill and shreller mill. This is a huller mill. It was causing a lot of nuisance near that Nandalapeta, right? So this Alapati Venkatrao and others, annoyed by the continuous sound of the mill, they have filed actually a case, civil case. So in this connection, the commissioner was also taken. He went to the spot. Of course, the commission stated that during the daytime, no such noise is coming. Night time only, it was heavy, and the court wanted to give some injunction. Ultimately, they went to the High Court. Ultimately, it was treated as a nuisance, and the mill was supposed to be stopped and to be shifted to other place. Right? So there it is a private nuisance because the person residing nearby, he has suffered it a lot. He filed a complaint, Nizamapatnam for Alapati Venkatrao, and he was successful. So briefly, these are the cases relating to private nuisance. Please read the cases thoroughly and enrich your legal knowledge. Thank you very much.